Present here. Good morning, sir. Welcome to the webinar. So today we are going to have our webinar based on some case laws, and our speaker is already there. Dimple, is chairman or vice chairman is there or not?
No, ma'am.
Oh, no. All right, no problem. So I am CA Ayushri Khanna and I am the moderator of today's webinar. Welcome you all. Good morning and happy Sunday, everyone. Thank you so much for sparing your time. Definitely it's a Sunday morning, but still you all are there. So hoping to make your time successful enough with our super knowledgeable sir, Mr. Sumit. So let me just introduce him to you so that we can start with the case laws and grab as much knowledge as we can. So C.H. Sumit sir is, if I talk about his qualification, he is BCom, FCA, DSA, CAMS, DIRM, and many more. He is registered valuer, insolvency professional, and independent director as well. So he's a chartered accountant having rich experience in the field of audits, Ind AS, implementing over 15 years of experience. He cleared chartered accountancy course in 2003. And you can see it's more than 2 decades, almost 2 decades is there. So prior to joining DLS Associates LLP as managing partner, he has also worked with PwC India for 5 years and KPMG for 4 years. And there is much more for his introduction. We are short of words to introduce him, but I welcome you, sir, to the webinar. So please grace your presence with your knowledge. Thank you so much.
Thank you, C. Ayushri, for the warm introduction. And good morning, all participants and chairman, vice chair, chairperson in absentia. Now, we all should know that every weekend when this Valuation Standard Board is organizing some programs, for sure, certain members will get benefited because of them, because those who do regular practice of valuations. Now, today's topic is more of case laws, and case laws, nobody likes litigation. Given a choice, everyone would like to stay away. What the valuation looks like, what two persons are doing a transaction, valuer issue a report. If both are happy, you can move ahead. Problem comes in when somebody is not happy with the valuations and he goes to the regulator. And when he goes to the regulator, everything starts opening up. It's like opening a Pandora box. Why you did that? What was your assumption basis on that? And we all will agree, valuation is not like 2 + 2 4. Valuation can be 2 + 2 5 or can be 2 + 2 3. Depending on which company I am valuing. So if I'm valuing a running company, value can be much more higher. If I'm valuing a company which is in the litigation, say for example now Future Group, ILFS Group, or now Go Air, which is gone under the insolvency, so the value will differ. Now whatever subjectivity it is, it can always be challenged by anyone. And when it can be challenged, as a professional, I rely on past judgments. So we like to go through certain judgments which safeguard valuers in their favor, that what should be taken care as a valuation fraternity. And in the meanwhile, whenever you have any questions, you feel free to drop in. Ayushri, I will take the questions at relevant time whenever feasible for all.
Sure.
Just a second. So before we go into the recent case laws, I'll just want to touch base with you on the iconic case laws of valuations till date. So in the history, we had 6-7 major case laws. And one of the biggest, and these case laws are very old, ranging from 1990s. So almost 40 years back. But still, even today, whenever a NCLT or a court passes an order, at times they still refer these judgments. So these are time memorial. So whatever has been concluded in Mihir Mafatwal in 1990s, even today, whenever, like last 2 years back, whenever NCLT has passed an order, they give a reference of this case law, that since it was decided in this matter, we will still hold that matter for good. So what was mentioned in Hindustan Lever? So Hindustan Lever, the issue was, can a valuer use multiple approaches? Can he do a combination of all approaches? So as we all know, there are three approaches: market, income, cost. A valuer can choose either a one value approach or can multiple approaches. Let's say SEBI permits to SEBI permits to use all three approaches. So in this case, since we are talking about 1990, where there were no valuation standards, no corporate governance structure, there was nothing written in law how the valuation should be done. So whatever valuer feel is right based on his judgment, he would have done that. So in this case, the Supreme Court approved that valuer can use combination based on his judgment, and he need to justify the judgment. In Mir Mafatlal, it was proved that you cannot challenge a report just because you are not happy with the report. Until unless you mention what is illegal in the report, nobody can stop that. In Renuka Datla, it was approved by, it was order were passed that a valuer will only value based on the terms of valuation you give him. You cannot expect valuer to interpret more which you have not interpreted. So if you have given something to valuer in plain writing, valuer will only do that. In GL Sultania versus SEBI, the Supreme Court ordered that it is not necessary for the SEBI to always take the highest value. SEBI can take the value which, in SEBI's opinion, is reasonable and is consistent with the valuation methodologies. In Dinesh Lakhani, again, the court concluded a shareholder cannot ask a valuer to change the approach, because if he change another approach, the shareholders might get a higher value, better value, but that does not mean we can push the valuer, we can push the valuer to change the approach as what we deem fit. And in Brookbond, Lipton, India, again, it is one of the famous talked about case. Again, the same principle that until unless something is grossly incorrect, the regulator will not look into the valuations exchange ratios and cannot interfere in the report. So these are the broad guidelines. And now, so most of the fraternity always feel valuation is less of science and more of art. When we say more of art, that does not mean I can paint whatever I like to paint. There is a leeway with me. Yes, there is a subjectivity with me. I can take some calls, but that call cannot be such which I cannot substantiate in court of law. If suppose a normal valuation given by me is 100 crores, and if the court appoints another independent professional and he gives a value 10 crore rupees, then he or I need to justify why there's a difference coming. Either my approach is absurd or his approach is absurd. So it is not what is right. It is the way you have done, is that right or not? Numbers are immaterial. What value I get is always immaterial. And what is material is the process you are going through. So we'll discuss 6-7 case laws which have made marks and which have huge challenges. The first case, which have just recently passed a few 2 years back, can the valuation report be rejected by NCLT due to parties' dissatisfaction? So we got a valuation and one party is not satisfied with the valuation. And first one thumb rule is we agree, we can never satisfy everybody in the world. You cannot please everyone. Somebody may be happy with your report, somebody may not be happy with your report. Now, if the report has been issued by a valuer, one of the party went to the NCLT and say that we are not happy with the report. So can NCLT reject the report since one party is not happy? Second, in this case, one more principle was again re-enshrined, again re-emphasized. What if a valuer makes a mistake? So we all will agree, we all are humans. Even a valuer is also a professional. He might make a mistake. And mistakes, there is a difference between mistake and error and fraud. We all will agree. There is a difference between error and fraud. So I could do an error, but if I do a fraud, that's a totally different thing. So what happens if a valuer had made a mistake and after some time the transaction got over? Let's say after 6 months, one of the parties observed, oh, there is an error in that. It might be a typo error. It might be a calculation error. It might be a totaling error, whatever it could be. Can the aggrieved party approach to the court after that? So those who are watching this webinar, if they can give their views on their quick question box or chat, what do you think? Whether the values, if they have made a mistake in valuation and after the transaction concluded, they can the aggrieved party approach to the court that this is wrong and now they want to reinitiate the transaction? Just think over this point, and then we'll go through what has actually happened in this particular case law, where the court has given a final verdict. So this was a matter of Dr. Syed Sabazat Azam versus Saheji Village Limited. This company and both doctor are based in Kolkata. So due to some dispute happened and they want to exit. So Dr. Syed wanted an exit from this company. So they went for a valuation. So the valuation was supposed to be done on 31st March 2010. A reputed firm of valuers, top 10 firms in India were appointed. They did a valuation. And when they did a valuation, they did on a DCF method, discounted cash flows method. And on doing discounted cash flows method, they made adjustments. And the adjustments were, so if you have 2-3 years old data, which was coming in your books, but no provisions made. And in 2010, we do not have any Ind AS where it has a mandatory expected credit loss provisions and all. So the auditors in the books were provisions was not there. For last 2 years, data is not paid. And then the value has considered them that, okay, certain haircut needs to be done. So value will come down. The petitioner challenged this report. He said the valuation should be done on 31st March 2010. So post that period, these kind of adjustments should not have come in. If in my audited financials, we have not made any provisions, then valuation should not have changed. And now when you are taking DCF methodology, the actual figures will be different from the projected figures. So DCF should not be taken. And because in this case, DCF was coming lesser value or equivalent to the NAV. So he says we should ignore that. That was the petitioner key question to the NCLT that I am unhappy with the valuation report. You need to take it out. Then NCLT said we rely on 3 judgments. So one is GL Sultania we just talked about. When I showed you the screen of 6 case laws. In the GL Sultania case, the principle was until unless you mention that the valuer would have departed from any valuation principles or approach is fundamentally wrong, or there are factors which have not been considered by valuer, we cannot say that the valuation is incorrect. Court will never ever interfere in the valuation of an expert until unless you prove that valuer missed certain things fundamentally. And one of the reasons why, because court always confirms and reaffirms, valuation is a complex assignment. Court do not have the capability to do the calculations. Court can only question on the approaches and fundamentality. So either you say valuer has not done something fundamentally right, then they will enter it. But just because you think that it may not be right, court will not enter. So GL Sultania was one of the cases which court NCLT has taken a view. Then NCLT has again taken a view of Mir Mafatla, which is again the Supreme Court judgment in 1997. And the NCLT said, in this case, Supreme Court concluded that the valuation of shares is a technical and complex problem. And it can appropriately be left only to the experts in the field of accountancy. So even court admits that yes, these valuations are very complex. A court cannot come and enter into as a valuer. Court cannot do the computations. Court can only see the reasonings until unless a person making an application and a complaint should mention that the valuer has missed these things intentionally, collided with the management, then only court will look into it. Just because saying my valuation is coming different from your valuation does not make me wrong or you right. Because even the court admits, even the experts will differ in their conclusion and even reasonings. And because it all depends on perception and all depends on upbringing and exposure. So let's say if I am sitting in a small town in India and I'm doing valuations of a property, my haircut percentage may be much different with somebody would be sitting in Mumbai or Delhi prime property, depending on the haircut percentages. So here also the Supreme Court had said that since Mir Mofatlal also, we have said that you need to show compelling reasons to upset the finding of values. Since you have not shown any compelling reasons, we will not interfere. Then comes the most important judgment here, that if the mistake is founded later by any party, can it be objected later? Then the NCLT has given a reference of a Delhi High Court judgment in 2012, which says that if a valuer honestly do his work and in his good faith, see the most important is he's working in a good faith and honestly. So he's not having any biases towards any of the parties between the shareholder or the management or the minority or majority. So then both the parties are bound by it because you are taking a help of an independent expert. So both parties should abide by what the value is giving. And then in the same law, it was held that even if the valuer makes a mistake, both parties would still be bound by it. Because if I made a mistake today and both of you have read the report, both of you have accepted the report. So when both of you have been going through what I have given you, even it is erroneous, then you both need to be bound by the valuation which I have done, even if it is incorrect. Only difference is if you mention that it is a fraud or collusion, then the result would be totally different. They say fraud and collusion unravel everything. So if it is an error, the court is happy to continue that error as it is, and both the parties have taken it. So many of the friends would be may not like the judgment and may have different view that means valuer has gone scot-free, that he made a mistake. Now one of the agreed parties is suffering. So nothing is fair in life. If the valuer has made a mistake and after 6 months, 2 years, you open it, it will be a Pandora box opening again and again. And it will be like layers of onion. The more you peel, the more issues will come out. So somewhere the buck has to stop. And again, valuer is just giving an expert opinion. The people putting money, see, as a consultant, you are giving an opinion. Your skin is not in the game. The person who is buying and selling, who is putting his money and selling his property, if they are accepting that mistake, so the things has to go on. And as I said, because it is subjective, nothing is right or nothing is wrong. It's how you justify. So even then the NCLT said, since he has not done anything fraudulently or colliding, we will go by his expert opinion. And in this case, the NCLT concluded that any valuation report will only be challenged by NCLT only on the ground of patent illegality, whether valuer is completely done against the law. You can prove there is a fraud, you can prove there is a collusion, or he has done partiality. So it may happen that the fees is paid to me by majority of the shareholders, so I might be biased towards majority. And you may say, okay, minority I have not taken care of. So if there is something which you can show that I am partial towards one of the parties, then only the regulator will open the report. Otherwise, they will never open the report. In this present case, nobody has said that it is illegal, just said they are not happy. And then the court said, this report cannot be contested and set aside if the parties were not satisfied with the valuation, because there is no way at every valuation certain parties will be happy with your report. So in this way, this valuation got clean and it went ahead. And the judgment became that unless nothing is wrong on illegality ground, collusion, fraud, the value will not be questioned. So this was a recent case law where it became huge. Now we are going to touch base on the classic case law or NCLT, which came into IBC, Insolvency Bankruptcy Code. So those who are IP professionals and valuers who work in IBC would know that in each IBC, 2 valuers are required. And when we take 2 valuers, their values supposed to come different. Even if they are Siamese twins, or twins or same family or values from same association, their value can never come same. If two values are appointed to value to one asset differently, if the value is coming same, it gives a suspicion that two people might have done a collusion. So the regulator expects if there is a difference between two valuers, we are okay. But then the law has given a provision, the what if there is a significant difference. So if I have given a valuation, let's say 100 crore rupees, and let's say Ayushri has done a valuation and she has given, let's say 130 crore rupees. Now, as a liquidator, as an IP professional, we need to give a mean value. We need to average a value and give to the consider it for my all discussion purpose, all transaction purpose. So the regulator has given a provision that whenever there is a significant difference, you appoint a third valuer. The third valuer report, once he gets the numbers, compare the three numbers, and whichever is the closest number, you do a mean value between two closest numbers and issue to the regulator, for all transaction purposes. Now, what is the significant difference? Earlier, it was not defined what was significant difference in the code. It just defined last year in the code. As of today, the significant difference is 25% in liquidation value. Earlier, people were taking 20% as a benchmark because there was nothing mentioned in the code. Since last year, they confirmed now it is 25% of liquidation value. Now, in this classic case of ICICI Bank versus Unimark Remedies, so Unimark Remedies is one of the pharmaceutical companies who had specialty that they were one of the 6 companies in the world who were making certain specific medicines. So it was a unique plant. It had huge intangible values. In the books, the value was coming 200 crore rupees. When the company went into insolvency and the values were appointed, they gave a value. Both the values give a nil value. Nil to fair value and liquidation value. So in IBC, every valuer has to give two values. What if the company continues? That is a fair value. What if we shut down the company? That is a liquidation value. So at times the question was also raised that why are we giving two values? Why are we supposed to even talk pessimistically on the day one of insolvency that what will happen if the company shut down? Why are we going for a liquidation value on day one? And again, the intent of the law is, so on the day when the committee is apprised that there can be two scenarios. Company may revive or company may not revive. So if it revives, what could be the best value? If it do not revives, what could be the last value which a committee can expect? So both the values have given nil fair value and nil liquidation value. Now the ICICI Bank was one of the major committee holders, COC. They were unhappy with this valuation and they requested the IP insolvency professional that we request you to appoint a third valuer because we are not happy with this valuation. Now, IP denied the demand for third valuation, and which IP was right in his wisdom to deny that because the regulation says a third valuer will be appointed whenever there is a significant difference. When both people have given 0, technically there is no difference. 0 minus 0 is 0. There is no difference. So you cannot say there is a difference. So he said, I cannot do that because my code do not permit to appoint a third value. The ICICI went to NCLT and they said that we are asking something for a liquidator and IP and he's not helping us. We need your guidance. So in the NCLT also, we all understand in every NCLT generally has 2 benches member generally. So in the 2, one is accountant member and one is judicial member. Judicial member generally comes from law, he would be a judge and something. Whereas accountant member could be any CA, CS, CMA or any other professional having that experience. So both the members have a diverged view on this. Judicial member said, we cannot appoint a third valuer because the code is silent and code do not give us a permission. The accountant member said, no, we have to appoint a third valuer because somebody has come to us and asked for a justice, asked for a third party opinion. Then why should not we? So both the judges from the same bench have a different view. And then whenever a situation comes like this, it becomes a deadlock. Because when there's a two-member bench and two members, one have a different view, one have a different view, then the decision cannot happen by flipping a coin. That, okay, if head comes, I win, if tails come, you win. That does not happen in a judiciary. So both the people were having a different thought process. So they approached to the NCLT bench. So when the same bench is a problem, they go to the senior bench of NCLT. The NCLT, the chairman, the president of NCLT, he asked the third judge of NCLT Mumbai to look into the matter and decide what to be done. Because something was coming first time which code was not there. So they look into that. And the key issues which was there is, does the educating authority, which is the NCLT in this case, do they have a power to appoint independent valuer to conduct fresh valuations of assets, even when the code is silent on that? And then to look into the valuation. Did the valuer made a mistake anywhere in giving a nil value, which is looking apparently nil as compared to ICICI, because ICICI believes that audited figures were showing 200 crore value of patent, and these valuers have given 200 crores. These values are given nil. So something would have been grossly wrong somewhere. So they wanted to go more detail into that. The background of this case was, earlier, in the books, the valuation was coming somewhere around 241 crores of plant and machinery and 205 crore was of intangibles. Intangibles mainly belong to patent, and we all will understand in a pharma company, more than machine, it is always the patent which is the value. So take example of our Poonawalla company, which is making COVID vaccines. So the patent is most important. The copyrights, the trademarks, and the patent of making medicines, that is the most important here. Plant and machinery is just a side show. So here the value of entire impairment has become zero. There are two main plants in Vapi and Bavla. Their valuation also has taken negatively. And as I mentioned, this is the company which is one in 6 companies in the world. There are total 6 plants in the entire world who can manufacture this carbapenem, and it was only one of them. So having such a uniqueness, they have not even considered the value of this. So then they said that it cannot happen. And then the ICICI Bank lawyers argued, it cannot have that a company which is one of the 6 in the world loses its value just because a value is giving zero. There, even the plant and machinery and the structure will have certainly some value. So we need to look into it. So the court asked the reasons, what was the issue? And the issue was, this company used to manufacture drugs and sell in various markets. They used to export in more than 40 countries. So US was one of the countries, and apart from them, there were 39 other countries in the world where they were selling their medicines. The company actually got a warning letter from US FDA department that we have visited your plant in Vapi and Bavla, and we observed following lacuna. And I'm sure those of you have ever worked for any sales company or company which has exports. At times you get foreign companies coming in India, reviewing you. So maybe somebody would not have wear plastic shoes at the time, or they would have find a child labor working in your, maybe the child labor is not employed in your company directly, but maybe the person delivering tea, he would be sending his junior, his son, or which is a minor. So these are considered negative, because even if the child labor is not your employee, but because he's coming and delivering in you, so your vendor should have been taken care of that. So they got warning letters that you need to follow certain rules and procedures, else we will sanction your exports. Based on this letter, the valuers considered value as nil. interestingly, in this entire period of CRP, the values were about to sell 80 crore rupees. Even after the warning letters, the values were able to sell the CRP, the company was able to sell 80 crore rupees medicine in that. So this became one more strong point that whenever you are in CRP, you can still sell 80 crores. How come you give a nil value just on the basis of receiving a warning letter? Then the then the ICICI Bank lawyers also said, we need to understand valuing a non-pharmaceutical company and valuing a pharmaceutical company is totally different. It may happen that the valuers fail to value the assets as per international standards. Because in a pharma, there's a different methodology. In a non-pharma company, is different methodology. So similarly, as we all will agree, even in case of audit, we just cannot say if I am a CA, I can do all audits without upgrading myself. Yes, I can sign all balance sheets, but each industry have a different nomenclature, different process, which I need to understand. So if I'm doing an audit of a sea oil company, let's say Bombay Oil, Bombay High Companies, so there would be a different understanding of capex. If I'm doing a normal company, under different understanding of capex. So you need to understand that, and valuer might have missed that. That was the allegation given by the company. When the valuation happened, both the valuers have given fair value, liquidation value nil and nil. Whereas plant and machinery valuation was also given very low, 38 crore, 49 crore. Whereas the third valuer was appointed by the company itself. The company had a joint lending, so they had a pool of bankers, and the bankers appointed valuers, and their values are given 529 crores and 434 crores, which is totally way ahead than what IBC values have given. Then this raised a question, and on the review of minutes, it was noted, had the company paid $245,000 to US, they could retain the license for exports and they could export to 63 countries. Despite having the license to export to 63 countries, this was not given any value. So it is just like a telecom company or like an NBFC. I form an NBFC, I get the license. Even if I'm not doing anything, if I sell the company, I have a value of that license. So that has to be valued because you got a right to do business. This was not considered. And then they say in a pharmaceutical, if you don't value the intangible, entire company value is zero because intangible is the most valuable asset in pharma companies. There was also a question that there was too much significant delay in submission of valuation reports by valuers. So this becomes a lesson for all valuers that if I'm doing any assignment and there is coming any significant delay for whatever reason, and mostly the reason would be non-availability of data from the client. But in that scenario also, you need to demonstrate that you have done adequate follow-ups. Email trail is there that you called and you followed up with the IP for giving a data. If he's not giving a data, you can't do evaluation. But if you don't have the trail with you, it becomes difficult to justify. And then they ask the question that both the values are zero, give a new values, which the IP denied, that it is not requiring fresh valuation because of the law. Both the valuers were having sufficient capability. Both the valuers had done more than 100 valuations of IBC cases. So the COC and the IP said, we cannot question on the capability of the valuers. Why the zero has been done, that can be asked. The unsuccessful bidders also raised a question. Now, in any IBC case, there are certain people who are willing to buy the company. So those who win the bid, they will be always happy because they got a asset at a very throwaway price. Generally in IBC, you get a very discounted price. So you can make a good bargain purchase in that. But those who are unsuccessful, they were not happy. So they complained that the valuation has not been done properly. And there is some goof up in the valuation reports, which need to be considered. But see the other side of the table, the successful bidder He said, whatever valuer has done is right, because he was happy with getting a lower value, because if the valuation would have been higher, he would have need to pay more money since the valuation was given 0. So he said, no, valuer has done a very right job. They had done perfectly whatever has to be done. No need to look into the further valuations. And he said, because in the ICICI objection was, in the books, there was 200 crore rupees intangibles. So he said it would have happened that the company had not recorded the impairment impact. So if the company did not record impairment impact in the books, the value will remain as it is of 200 crore. Else it would have gone much below. However, the promoter was very clear that the valuation given by valuers is not right. And the promoter, because the owners of the company Unimark, they wanted to have a better value so that the loans could be set off and they would have less troubles. So he said that according to him, the value given by IBC values is 44 crores and 26 crore rupees, fair value liquidation. Whereas the same assets have been valued consistently by 3 years by various joint lender forum banks committee, their valuation was coming 500 and 400 approximately. So there is something fundamentally which values are missing. And then he said, having a valuation certificate does not mean you have the expertise to value everything. So they say it just like, let's say, as I just talked about, if I am an auditor, I am a CA, but if I don't know systems audit, then it does not mean just a CA I have a right to sign on systems audit report. I need to know the technicality of system CISA and DISA qualifications. So here also they say the values are lacking expertise to value IPR companies. They missed an important point. Yes, we received a warning letter, which is fine. We are not denying the fact that we have not received warning letter. But then there is a difference between a sanction letter and a warning letter. Warning letter is just like a sanction, just like in a school, if anybody would have you got a red card, red slip, that does not mean you are rusticated. Red slip is a warning that if you do not behave properly next time, then you will be given a TC. So it was given like a red slip. So they said that the fundamental thing, and the court also asked the valuer, the fundamental thing they missed was the letter was only received from one country out of 63 countries. If I am exporting to 63 countries and only one country, US, has a problem, what about 62 countries? If they have not had any issue, why can I assume 0? We are not denying the fact that we received a warning letter and we need to work out. But this warning letter is like a housekeeping job. If you rectify what the things they are wanting, so if they are saying you need to have a ducting, you need to have shoes should not be worn, it should be plastic slippers, something like that, which is doable and can be done, then there should not be any reason to value 0. That was one of their arguments. The values I've just given, again, the PPT will be shared to you all shortly, so I'll not read line by line. I'll just take the key principles and move ahead. And the values are given the same logic, that because the warning letter has came and the warning letter is in public domain, so everybody in the world knows this company got warning letter, so it will have adverse impact in exports. And since everybody knows it, it may happen the buyers may not buy, or if in future, so here something a value should not assume. So he assumed that if in future the US issues a sanction on us, then my exports will be stopped and then my plant will not function for 3-4 years. If my plant will not function for 3-4 years, then my plant value will get deteriorated. So this is something value should not make an assumption until unless something is crystal clear. And based on that, he said my valuation is nil. Second valuer was asked, and second valuer also said the same thing, that based on the same letter, I consider it as a significant warning letter, and if it impacts my export, my plant is expected to have a huge negative impact. Therefore, I am not considering any impact on these valuations. So they've given nil. Then the NCLT judge who called the third judge, he said, whenever a such case happens in valuation of intangibles, especially in IBC case, we need to look few things. Whether the balance sheet is showing that value, if the auditors are showing that value, there has to be some base. whether the letter which has been shown is a warning letter, it's a threat letter, or just a compliance issue or serious sanction issue, that need to be seen. Whether the committees have considered these observations in their minutes. So this only the IP should have known. Then the court NCLT bench gave a judgment. There is no letter which says that ban has been actually imposed. And if the ban is not imposed, then you cannot say value can be nil. The warning letters are just for a company from US and not from other countries. And the company was continuing export to other countries. So you cannot stop. And then the NCLT judge view was the reasoning of the valuers in assigning nil value is absolutely untenable. So according to them, it does not make sense to give zero value. And the valuers have not considered the importance of pharmaceutical companies' valuation, where intangible assets derive the company. So it is typically, like as I mentioned, like telecom company. In a telecom company, if you do not value the license which the TRAI gives, entire company is of no value. You cannot say, okay, tower is very good, so I'll give you value of tower. What the tower will do if you do not value the 2G, 3G, 5G license, whatever you have. And then again, the court said, again, the benches are very clear. Bench says, we understand valuation is not an exact science. And we'll just not disregard a report because there's two different numbers. Until there is a patent error. If there is a patent error which can easily seen on the face of the report, we will reject that. So in this case, they have rejected the report and asked the values to, third value was appointed and a new valuation was done. So then we need to understand at times a valuer should not take a subjective calls negatively on its own. He need to look oversight. He need to look entire orbit needs to be looked. Just one sanction, one letter cannot determine the value as nil. So this was a classic case where the both values come zero and it went against the valuers. Where and since it was a new case, there was no penalty action levied on valuers because valuation profession was evolving in terms of IBC, but they were given a warning that you need to look properly. Now, another interesting case in the same time, in the same timelines, was of Indian Bank versus Solidarity India Limited. So this is a case of a Chennai, and those who are from South side would be much aware of this company. This is again a classic case where in a liquidation value, both the valuers gave value of land 31,700 rupees. So 31,700 is a very small amount. Whereas bank view, Indian bank view was, I should at least got 18 crore rupees. Now you can see the North Pole and South Pole. The valuers are giving 31,000 rupees, which is just like a chiller. And the bank was expecting 18 crore rupees. And again, the interesting fact same here. Both the values give the same value, 31,700, 31,700. Again, the bank went to liquidator, bank went to RP, saying that appoint the third value. RP said, I cannot appoint the third value because there is no difference. Since there is no difference between the valuation professionals, I cannot go to the NCLT. Indian Bank went to NCLT and again, NCLT said the same thing, that the law do not permit me to appoint third value. And since both the valuers have given same value, so there is no difference. So we will not look into your case. Then Indian Bank appointed their own valuer. So every bank has a panel of valuers. Indian Bank appointed their panel of valuers. Their valuer has given 18 crore rupees value. And based on that report, they again went back to NCLT saying that, look, our value, we got a report now. Our valuer is now saying that the liquidation value should be 18 crore rupees. Now, when a public bank comes to a regulator and says that if I do a transaction at 31,700, there will be a lot of public fund loss because this loss will be borne by the bank. So now the regulator has to look into it. And then the regulator look into it and the regulator says, now we will ask and inquire why the value is given only 31,700 and not 18 crore, which is allegedly claimed by the bank's own values. So here First, everybody thought maybe the values would have collided. That's why it's giving same numbers. Or maybe they missed to read something which the bank's value would have read better. It was always about interpretation. So everybody thought it may have that being companies going into IBC, they would have taken a conservative view and ignored the valuations. But then, interesting part was in the order was, the bank says their liquidation value determined by RP is decimal in value as compared to 18.74 crore. So as according to the bank, it should be 18.7 crore, whereas the RPs have given only decimals, 31,700, not even coming in decimals there. Whereas the same bank has got done in 2019 again valuation. So the loan was given in 2013. So the bank has given loan in 2013. At the time, the property valuation was coming 17 crore rupees. Now in 2019, the value will increase a little bit from 17 crore it went to 18.74 crores. Then they say how it can happen that in next year, in 2020, the value will go down to 31,000 rupees. So something grossly wrong. Then the valuer asked, the court asked the valuers, what is your issue? Then they say, so the bank said that value is too low. We ask fresh valuation. That's the request they asked to the court, that please allow a fresh valuation to the case. RP said, he asked the valuers give a judgment, and RP said, why the value is given 31,700? The company has got a land assigned from Tamil Nadu. In Tamil Nadu, there is a Tamil Nadu Industrial Development Corporation, TNIDC. So in 1989, this land was taken from Tamil Nadu. It was not purchased. It was assigned. So there is a difference between purchase and assign. In a purchase, I have a right to sell to anybody. In an assignment, can I sell to anyone? So all will agree. The answer is no. In assignment, you cannot sell to anybody. Nor even I have a right to transfer somebody. So let's say if I am not running the business, can I say no, instead of me, you take it? Answer is no. So in that scenario, this 31,700 was like a deposit money which we have given to Tamil Nadu government. And the condition was, whenever we return the land back to them, or we get insolvent, or we shut down the company, this is the only amount which Tamil Nadu government will give us back. So that was the only amount they considered as a liquidation value to be received, not 18 crores. Now we need to understand the issue, what would have happened. In 2013, when the bank would have given a loan, their valuer might have missed this point between the difference between assignment and a transfer, or it may be the bank had to do the loan, and to cover the targets, 18 crore, the such value could be shown as a collateral, just for any reason. Again, these are assumptions, because I've spoken to both the valuers that they say, we read the original document and everywhere it is clearly written, the land is assigned. It is not that land is transferred or land can be transferred. It is just assigned. So technically this valuation cannot be there sustained at all. And then the court reviewed the document and say that land will only fetch the money which Tamil Nadu government will return back. That is 31,700. Even the assignment does not give them any right either to alienate the property nor to transfer to third party. Like it can happen, like, if I'm not running the business, you come and take over my business. Even that also is not permitted in that terms and conditions. So when nobody has any right, this land cannot be used for any purpose other than assignment deed. Also, the CD cannot create third party rights nor transfer. When nobody can do that, then the valuation cannot be 18 crores. It will go down only to 0. Yeah. So then the court said the valuation which you got 18.74 crore is not talking on the title of the land. So we need to understand, yes, I am having a possession of a land and I am working on that. I have made a factory on that, possession is there. So there is a value to that land as long as I am working on that. I cannot say if I'm running a business, the value is 0. If you are running a business on it, there has a value. Because if I would not have made a building here, I would have made building somewhere else. So there will be a value of the land. But the moment I'm selling the company, that value of land cannot be given a value because I cannot dispose that land with me. The land will go back to the Tamil Nadu government and I will only get 31,000 rupees. So when the title asset cannot be transferred, you cannot question. And again, in this, the NCLT says, we are opinion that the valuation given by valuers is right. And we don't need to re-examine by looking at the allegation made by the applicant. So this was again one of the classic cases where it was decided that even the valuation coming low, both the values are giving the same, you need to justify that. Now I'll take one recent case, just give me a minute. One recent case where there's an issue on, there is a significant issue on valuation because valuers have ignored a property. And this becomes very important for those cases where you are doing a valuation of a company and there is a asset which has a litigation. So let's say company has a property and that property has a litigation issue. Now, should you give value to that or not? That becomes a huge challenge. So this is a company based in Odisha. In 2022, the judgment came in. So it's a very recent judgment. And it becomes a landmark judgment in NCLT cases of, at least in valuation cases, which a valuer need to keep in mind and also for insolvency professionals to keep in mind. So just to give a background, what is in the, and understand what would be your position, what will you do? You are supposed to sell a company and company has a land bank. And in the land bank, there is a title issue. There is a dispute going on with the government for some reason. If there's a dispute going on with the government, there is no surety whether the land will be with you or may not be with you. So 50-50. Right now, you are having the possession of the land. But on a title, there's a dispute with government. And when there's a dispute with government, it needs a different level of skills to fight with government. Because when you are fighting with government can anytime change a retrospective law and you might go against that. So that becomes a challenge. So will you consider that value of the property in selling? Yes, no, maybe. So that becomes a challenge. So let's say I have a land of 1,000 crore rupees. I'm not sure whether it will remain with me or not. It may happen, government may take it, or it may happen that I might get it. I may get out of 1,000 crore, 500 crore rupees value, may get 800 crore rupees value, or may even get zero also, which depends on each specific case laws and technical details. As of today, I don't know what may come in future. Now I need to sell it. Actually, what you would have done if you need to sell, will you consider the value, ignore it? See, as a buyer, I will always ignore. As a buyer, I will always say, what is the value? It is a case law. Aayega bhi nahi aayega, bhavagan jane in future. So why should I pay money to you? As a buyer, I understand the observations. But as a seller, would you like to leave or would you like to consider?
So if I consider the prudence basis, so definitely I need to be on a safer side and consider it to be nil until unless the dispute is over.
So at least some consideration should be given. At least we cannot say give 100%, maybe some probably based or something considered should be given. So in this case, that was the issue which the valuers and the RP ignored that valuation, saying the reason that since there is a dispute of title or ownership and in absence of evidences, we are giving nil value. So valuer might have given a nil value, which is fine. As a conservative, there is no question on that approach. IDBI Bank was one of the key stakeholders, COC. He said that the same valuer, interestingly, just a second, the same valuer has given a valuation in CRP 1,332 crores. So 1,332 crore valuation they have given. In a liquidation valuation, so the liquidation valuation happened after 3-4 months, after 4 months, the valuation was given 223 crore rupees. Approximately 1,000 crore dip in value, which is very, very awkward, which is abstract. From just clear review, somebody says the value cannot deplete so much drastically that you are saying the value of the company is 1,300 crores. Next 6 months, say you know it is now 223 crores. We understand stock market goes up and down, but the value doesn't go up and down that much, especially in a real estate issues. So the COC demanded a fresh valuation, which liquidator did not accepted that demand. Liquidator said, I don't think I need a fresh valuation. Just because you are saying number has gone down does not mean I need to do a fair valuation again. The key issue was this valuation came in without taking a disputed property into account. And that is a prime property. So imagine like if you are in Mumbai and you have a disputed property in Nariman Point or Kolaba, and you say, no, I'm leaving that. That does not happen. Or similarly, like in Delhi, you are in Janpath. Let's say prime property, you need to get a valuation of that. Had the value would have been taken, hypothetically, the valuation would have come at least 1,000 crore plus. So IDBI says this is a loss straight away to the bank, because what is happening if I sell the property today, sell the company today to the new buyers, the judgment may take after 5 years. It may happen after 5 years, the court decides in my favor that no, the property belongs to Jaipur Sugar Company, the property should go to them. So who will get the benefit of this 1,000 crore? The old shareholders or the new company which has bought it? It would be the new company which has bought it. Is it fair for the new company to get the benefit for something which they have not paid the price? So since it is not included in the valuation, they have not paid the price for it. So they say that either the report should have considered this, or there should be a provision made that in future, whatever money comes from this property should be given to all bankers who have booked a loss today. Now, the reason why the valuation got dipped, and the reason that we'll go through the judgment also, that straight away judgment. Here they say that another issue was valuation was done in liquidation inconsistent with CRP valuation rules. So there are CRP guidelines in valuations in IBC, how valuation should be done. So as I mentioned earlier in IBC, for any case, two valuers are appointed. So two valuers are appointed, valuer A and valuer B. Valuer A will give me, and see, two values are for each asset class. So if I have a land and I have a plant and machinery, I will appoint two values for land classes and two values for plant and machinery. So both the values will give a value, and both the values will give me fair value and liquidation value also. They will also say, okay, if the company is running, land will give me 100 crores. If company is shutting, land may give me 80 crores. So both the values will give fair value, liquidation value of each asset class, and then we'll compare, we'll do an average of it. In this, now, after CRP, if I'm going for a liquidation, it is the valuers, it is the liquidator call. Should I call for a fresh valuation? I may rely on the past valuation. So maybe I would have done the past valuation of the valuation done by A and B. I might take their liquidation value also. But if I think that there might be a significant change in numbers due to COVID or due to any other external environment, I can call for a fresh valuation. So he called for a fresh valuation, but he made one mistake. And the mistake he did was, he appointed only one value for each asset class. So for land and building, he appointed only one valuer. For plant and machinery, he appointed only one valuer. So then it becomes a challenge that whatever has he done is right or wrong. His view was, it was my call to appoint for a fresh valuation. So I've taken only one valuation of only one class. The prime property which we just talked about, it was in Rajawada in Odisha. There was a dispute due to litigation. Therefore, liquidator has accepted zero valuation given by valuer. Now see, there are two things. A valuer can give any value. I can justify in my report whatever I'm writing. It should be also the conscious call of liquidator to accept that or not. So a valuer is given a zero value saying that there is a dispute in litigation, so I'm not a competent person to decide. So I'm giving zero value. Right or wrong, that's a separate story, but valuer has given that. Liquidator accepted the same. And then COC said, if the case decides in favor of a company, then the proceed should be shared with the committee of creditors only, not with the resolution applicant. So this clause have not been put anywhere in the report. This is causing a drawback on the company's valuation, and we are earning huge loss. He appointed only one value, whereas Rule 35 says that minimum 2 values should be appointed for each asset class. Just appointing one for plant, one for land does not mean you appointed 2 valuers. Another issue was, which again is an alleged issue, can we share the valuation report with the prospective buyers? Yes, no, maybe. Ayushi, what is your thought? Can we share as a liquidator, as a resolution professional, can I share my valuation report with the prospective buyers?
Maybe not, sir.
So in fact, even the report even cannot be shared with the committee of creditors members also. You don't share the report to maintain the authenticity of the process and maintain the effective price discovery. If you know as a buyer what is the valuation coming in, will you be paying me more than that, or you will be paying me less than that? I will be always paying you less than that if I know what is the valuation you are giving, because that's a bargaining I can do. So I know if you have given me valuation is 100 crores, so that means 100 is the upper. So I will go with the start with 70. फिर आप बोलोगे नहीं 100, फिर 75. चलो आपका ना मेरी 80 पे close करो. We'll do that. So this report is never shared to the buyers, and the bank said we got evidences that the report was shared to the prospective buyers, which is totally inconsistent with the spirit of the IBC. And as a valuers, we also need to ensure, as a valuers, our report should not be shown publicly anywhere in any forum. If I would have done any valuation of any company, public will come to know. I just go to the IBC website, put the company's name, they will come to know who did the valuation. But what valuation report I issued, how much valuation I have mentioned, until the case comes to NCLT, number never comes public. So you need to ensure that you need to tell your team also, or your colleagues who are doing that, number should not be shared with anyone. Because at times, if you're doing a high profile case, which is coming in newspapers, let's say ILFS case, if somebody would have done a valuation of ILFS, which is a most talked about case, and you start sharing, oh, I did the valuation of ILFS and I give a value of 100 crores or whatever numbers, it is not a good sign of professional practice and ethical relationship. So one should never disclose the numbers. So here the report was shared. Now NCLT asked for fresh valuations, and there's a reason why NCLT asked for fresh valuations. I'll quickly just give a minute. I'll take you to the judgment of NCLT. Just give. Yeah. So this is the order given on this company. Now, where if you see what are the issues coming in this order. So the first valuation was 1332 crore, as I mentioned. This Rayagada, which is the disputed property, at that time the valuer has given a value of 1087 crores. So the value of land, building, they have given total. So this value of land itself, if you remove 187 crores, it becomes a huge issue. So this was totally removed out in the next valuation. So this was given valuation in a CRP manner. Then the court said, because Rayagada is under liquidation, hence liquidator take a legal opinion. Liquidator took a legal opinion, and this opinion was shared with the valuers. And in the legal opinion, the valuer has mentioned. Now, interesting part which valuers missed first time and the committee missed. In the opinion, it is said the total property is of 784 acres, which is a property which is under dispute. Whereas we are already holding a position of 565 crores. So we are having that. We have already surrendered to the government 117 acres, which the government has occupied for any reason. Now, this case is going since 1974. And you know how it takes in a government. So 1974 onwards, the case is going on till 2019 on the issue of litigation on property. because it was a manganese ore factory, sugar company, which is a different requirement of land. And for every for a sugar company, sugarcane is important. So they needed some extra land. All the lands were in the position was already with company. Position was already with the company. There are certain portion. So they mentioned that there is a dispute with government of Orissa. Dispute is already under High Court pending. Now, if certain position is also there, and it was written that if you do some compromise with the government, remaining property will be yours. So just saying zero value does not make sense. Because if it is mentioned the opinion that you do certain compromise, so if out of 700 acres land, if I need to give 200 acres, entire 500 becomes mine, I cannot say value is zero. So at least some value is from that 500 crore. The lawyer gave opinion that the land in question is into government proceedings, so it is not marketable and it cannot be disposed of, it cannot be mortgaged. So when the legal opinion came like this, valuer immediately gave a zero value. The same value which has given 1300 crores value earlier, 1000 crore value to this property, straight away he gave a new report, addendum report, and say now value is zero. Just so the valuer says, so because of the legal opinion, the registered valuer said he has given a zero value, and he given an updated report and saying that in the report he says, during the process of valuation, I asked for latest legal opinion. I was provided with one opinion, which was something different. So based on that opinion, we give a valuation based on the information provided to us. But later on, NCLT Chennai declined to accept the valuation, saying that due to legal dispute. So we again took another valuation. Then the NCLT asked them to revisit the report. When the NCLT bench asked the value to revisit the report, he said to revisit a report, I again asked a new valuation legal opinion, and which a valuer is a right. And see, we need to understand valuer is not a technical expert on the position of title. Title can only be confirmed by legal position. Valuation can only give the value based on the title. So he has taken a legal opinion. He asked the company to obtain a legal opinion. Company took a legal opinion from a certain advocate, and advocate this time given a report that which was different from the previous advocate. Previous advocate said the company can use the land and at least has the value. This advocate said that in his opinion, neither the land can be sold nor can be mortgaged. So this opinion completely changes the background and the values we arrived at the earlier exercise. So what the report he has given in 3, 4, 6 months back totally changes now. And that's why he's now giving a new report on 20th October. That's why we are considering value as a zero. So this becomes a huge fundamental difference from 1,300 crore to 278 crores from one value. That was the issue. Now, similarly, the other valuer has also considered the assets, and he has also given the lesser value. Then the NCLT have given a view that both the values based on the legal opinion has given a value zero. Now, the valuer, the liquidator has ignored this property, because if you ignore this property in a asset memorandum, the COC will always be a loser end. So then they said that you need to take that, and then just so then here comes the judgment, which court says it is pertinent to note that based on the legal opinion from the advocate, the CD is in the possession of lands 784 crores. 565 crores is already with the physical possession. Company has already surrendered 17.96 to the government. In that scenario, at least the valuation of 565 crores should have been considered. Just because you are saying that 228
I think there is some technical problem. Let's just wait for him.
Value of the assets. Why from SURFACE to IBC or any other law from RDBBFI or SICA, the key principle of IBC is maximization of the value of the assets of the corporate debtor so that the committee of creditors can get maximum recovery. They incur a minimum loss. That was the objective. If the valuer, based on the apprehension that due to dispute of 228 crore rupees, 28 crore acre, entire 560 crore acre should be given nil, that does not make a common sense. And that's what the NCLT did not appreciate it, and they rejected that. And they gave a speaking order that since report of the RV is giving zero value is not valid in the eye of law, because they have not considered the consideration of IBC, that is maximization the value and giving a fair and liquidation value. So they were asked again to do the valuation. Now, second issue which was arised was, is it necessary to appoint mandatory two valuers? So because as I mentioned, when we are doing a valuation first time, two valuers are appointed and two values give both the values, fair value and liquidation value. Now, law does not mandate that when you are going into liquidation, you need to again appoint two valuers. Law does not mandate. But however, if you think that substantial time has been passed and there might be difference between what valuation done earlier and might done today, then you may again call for a fresh valuations. Now, whenever you are doing for a fresh valuations, then it needs to be with the regulation 35. And what does the regulation 35 say is that in that scenario, you need to appoint two valuers. They say when you are doing valuation for liquidation again, appointed two valuers and consider the average of two valuations. You will do only average when you will have two values. You cannot do average of one value. So it says that you need to appoint a second value. And since valuer is not, if taking fresh opinion, he need to appoint two valuers. So he was taking a fresh valuation. He only appoint two values of different class. He did not appointed two values of one asset class. And then the court said that since he appointed a valuer, he appointed only he did a fresh valuation, but he arrived only one set of values. And the liquidator has not opted from second set of values. So just by appointing one for land, one for plant, it does not serve the purpose of law. So this has to be considered, and he has not appointed second value. This needs to be again read. So this was the drawback caused on this. And then they asked the second set of values to be appointed. That's why this was considered. So this was that it should be 1,000 crore. It's a typo in the order. They say had they would have appointed a second set of value, the second set of value might have done a better job. And then the decline in the value of 100 crore, which is 1,000 crore, should have been averted. So this is what was the final judgments in this. Just a second, let me see if there's something important. And again, the same liquidation cannot be a zero. So this becomes this is not a valuation issue. This is just for an IBC issue that if you have a litigation property, you just cannot say, I will put it zero and get it transferred. Because if in future the benefit is received, ideally it belongs to the previous creditors. Okay? This was all in the case of similar. Just a second. Yeah. So let me just give it. If you have any questions by the time, if you receive any questions, Anushri or Ayushri, something on.
So till now, I believe everything is crystal clear. Even, this is for the first time I'm so much interested in valuation cases. We have not yet received any of the questions. If some questions that I'll let you know.
Sure. Just give. So now I'll take another case recently of Appu Hotels, based again in southern part. Again, this becomes a huge talked about case, especially those who are from Tamil Nadu side or south side will be much aware of this case. It becomes a too hyped case. Again, this is a Appu Hotels group supposed to be taken over by Lee Royal Meridian. the value of land supposed to be 1600 crores, hypothetically or realistically, but the number came 423 crore by valuers. Now, we need to understand this is after COVID. And when the COVID hits, there can be various assumptions which could have been taken by valuers, saying that the valuers might have taken a view that now we don't know the future, whether the property will be sold at that price or not, or there could be various assumptions that would have let the value go down. It could have happened that way. So when a values have given for 23 crore rupees, many people started to give a bid to acquire. Interesting thing happened wherein the promoter itself came and promoter said, if you think 423 crore is a fair value, let me give you 1000 crore rupees, you give me the land back. So the original owner said, and when somebody gives a commitment like this, makes a statement like this, so it reaffirms his faith that the value given by you is absolutely of no value. I consider my value to be more than that. And he also got a valuation done from another IBBI registered valuer who gave a valuation of 1600 crore rupees. So this becomes an issue. What is the issue that values have missed? Now, in this case, the issue was, since the valuation is given a value, the COC feels that we have not got proper fair value. And one of the reasons was, they say that the values were appointed to the valuation were not of Tamil Nadu. They were from Delhi or outside Tamil Nadu. So it is the apprehension of the COC that they had little knowledge of prevailing real estate market conditions in Tamil Nadu. So as we all will agree that India's demography is such a big that if we put 27 Europe countries, they will come in form of India's map. So it may, if I am born in Jammu, I cannot say I have, even if I'm a land valuer, I cannot say I have a knowledge of valuation of entire India. Whatever the dynamics in Jammu would be there, in Tamil Nadu would be totally different. So unless I go on the sit at the land, I may not know the pictures. Can I just do a Google and find out what is a land rate in Tamil Nadu and say this is a fair value? Probably no. Google will give me a basic information, but the real transactions I need to either go and find out the registrar of land department, or I need to find out the brokers who's actually working in Tamil Nadu area and give me the real update. On the ground job will always give me much more clear information. So here, one of the issue was the values were coming from Delhi. So they say that since they are not of Tamil Nadu, they might miss the important real estate conditions of Tamil Nadu. Second, they say that the valuers, again, the same case which we discussed in the first part of intangibles, where the COC questioned, valuer seems to lack adequate experience in valuing the pharma companies. Here also, the COC said, valuers lacked experience of hospitality industry. So you are a valuer does not mean you have experience of all. If you have done any hospital industry, you'll agree. So I cannot say all buildings are same value. In hospital, you make buildings that based on certain different structure. You need to have a dustbin separately. You need to have a vent out where you discard green trash, red trash, biomedical waste separately. So there is a different building, different way. Similarly, like sugarcane industry or cement industry, your buildings are not normal buildings. These are different buildings because at times the building might be like a plant. So those of you ever gone to sugarcane industry will know the building is actually like a plant, because they make building in such a way that the production happens and the building works like a plant, because you make such a high-rise building where the pulp is excavated. So depending on the experience, depending on the specific industry knowledge, you can do a better valuation. So they say that we feel that valuers have only done a core assets valuation and ignored non-core assets. That's why it has not been properly valued. And the valuers did a desktop-based valuation, in the sense the real values did not went there. They asked their colleagues in Chennai to do the valuations. So the valuer said, due to strict lockdown. So 2020, everybody know it was a strict lockdown. It was a quarantine going on, and travel restrictions was there with everyone. So they say that the person who were appointed, they could not visit the place, and their team members. So they appointed their network professionals. They may not be IBB registered valuers, but those who are their connects, they visited, and because they were not IBB registered valuers, COC assumed that they lacked the expertise to conduct the exercise on their behalf. And also, IBC regulations mandates physical verification is mandatory. You cannot avoid going there physically. Even though the law do not permit that time, even the law says due to strict lockdown, ideally we cannot say just because physical is not permitted, I will do a desktop-based valuation, and sitting in office I can compute land and building and plant and machinery valuation. Practically, that could not be possible. Therefore, the respondent has ignored and have not done the valuation by going physically. That was one of the challenges. There was also one more issue, that one valuation report which was given in the name of registered valuer, he was not IBV registered valuer. By mistake or intentionally, he put the name of some other valuer. So which was again considered incorrect thing. It is like I signing a report in the name of Ayushri Khanna. I took the membership number on website. You cannot do that. And you cannot say it's a typo error. If it's a typo, then it will be one of the brilliant typo errors. Somebody can do that. So then they say that this is something which is wrong. He has done it. It might look, it is a tainted with fraud and malice intentions. Key issue in this was again, the basic rule of companies that valuation was not followed. One of the rules says that if you want to take assistance, ideally it should be taken only from registered valuers and or experts. And if you are taking this assistance, their details should have come into the report. So you have taken the help. So they are saying, the valuers is saying that I have taken the help from a local associates, but their credentials as absent in the report. You have not mentioned in the report who would be the people who will be doing valuations for you. What is their credentials, that you have not mentioned. Since you have not mentioned those credentials, how come the reader will rely? So this is technical non-compliance of your valuation rules. The valuation given by the values were 423 crores. The promoter got the valuation done by another IBB registered valuers in September 29. That is just 6 months before the lockdown. According to him, the value was 1641 crores. Now imagine when you have a one IBB registered valuer who is giving a 1641 crore value and two IBB registered valuers who are giving 423 crore rupees. Somewhere it looks that somebody is missing drastically something. And that's why when the plans came at a very low price at 400 crores, something approximately of up to hotels in Lee Meridian Group, NCLT cancelled the plan and said they need to again relook for the valuations, because if the promoter is saying I will give you 1,000 crore rupees because I know even the land value itself is 1641 crores, that means the COC will do a huge loss. So then they cancel the plan. So as a valuer, we need to understand here, as a valuer, practically we cannot travel entire India and do valuation on our own. So we need to take help of associates, and which is particularly fine. But they should be qualified, capable to do the assignment. And if you are using the help, those credentials should be mentioned in the report that yes, I relied on work of these associates. Ultimate responsibility will always be yours. I cannot sublet my responsibility saying that they have done that, so they will be responsible for that part. Responsibility will be only on your part. But without mentioning their details will not be the right way of completing your evaluation report. And that is specifically mentioned in clause 8, clause 2 of valuation rules, that whatever help you are taking from experts, that needs to be demonstrated and mentioned in the details. And that was one of the cases. So apart from the major NCLT cases, this one Supreme Court case, probably all valuers and all would love. more than valuers, all IPs have started liking this case. This case is of Alok Kaushik, plant and machinery valuers. It started with NCLT. And in this case, Bhuvneshwari was IRP and RP of this case. A company went into IBC and IRP was appointed, Bhuvneshwari was appointed as an IRP. In turn, she appointed they appointed the plant and machinery and other valuers. So the valuers have done the work. They started doing the work. It was an infra company. 83 locations were there pan-India. Out of 83, 40 locations Mr. Alok Kaushik has physically visited. And remaining 40 other locations, his team and associates have visited and did the work. For some reasons, the creditors have out-of-court settlement and they put the application to withdraw the IBC. So they went to NCLT and say, we want to draw back. We don't want to continue. It went over, NCLT approved for withdrawal of case, and any regulator will be okay if you follow the minimum guidelines, because no IBC intent is not to always close the company. Intent is to resolve the dispute between financial creditors and operational creditors. So when FCs and companies are okay, the IRP and RP went for withdrawal. The issue comes for the payment for the valuation fees, because you did the valuation, but we have not submitted the report. So if you have not submitted the report, would you like to take the report? Would you like to pay the fees? IRP says I cannot pay fees from my pocket because I am acting on behalf of company, so I am not responsible. Company says we have not appointed you. We have been appointed by IRP, so check from IRP. So they were putting ball in each other's court. COC said, since we have already shut down, we are not liable to pay. So it becomes a huge issue who should pay. So the first valuer approached to the NCLT. NCLT ignored his demands and rejected him. Then he went, when you lose at NCLT, then you have a right to go to NCLAT. You can go to the upper authority within 30 days. So he went to NCLAT. And when he went to NCLAT, NCLAT said, we have already paid you 50,000 rupees. That is sufficient. We would not like to discuss further. You go back to NCLT. Then when he loses at NCLAT, then you have a choice to directly go to the Supreme Court. So he went to the Supreme Court, and within 45 days you need to apply. He applied to the Supreme Court, and Supreme Court said, you go back to NCLAT. Now he said, do not play ping pong with me. First I went to NCLT, they sent me to NCLAT. Then NCLAT said, you go to NCLT. Now I lost everything, so I came back to Supreme Court. Now you cannot say go back to NCLAT because they are not able to decide. So ultimately you need to do justice. And we need to appreciate the patience of the valuer who has actually had the guts and stamina to continue fight with the authority. So he went to Supreme Court, and then Supreme Court gave a final judgment, which becomes a landmark verdict in fees related to the professionals. So it was primarily given for valuers, but more than valuers, all IPs have now relied on this judgment and have taken their dues also out of it. So the key issues here was, RV was appointed to value plant and machineries. More than 84 sites was there, and he visited 40 sites. So work was done. So it is just like you gave the order in a restaurant. He give me a pizza, burger, or sizzler, and he started preparing it. And then you says, ab bhook nahi hai. The guy has already did all the work. Whether you like it or not, you want to have it or not, you have tasted or not, you need to pay the fees. And then that's what the issue here. The CRP was withdrawn. So they were not paying the fees. So NCLAT said to the NCLT that at least decide on the CRP cost, whatever efforts somebody has done, he need to be rewarded. You settle the matter, that's good, but somebody has actually done the work. So NCLT said, we will discuss the fees and 20% we will reduce. So let's say if rupees 1 lakh was decided for your fees, let's say 20% we will reduce from you and give back you 80,000 rupees. So RV was okay, that at least something is coming, it's fine. RP cancelled the appointment, and later on RP said, give me some more haircut. Discount सबको अच्छा लगता है. So RP said also, give me more, 20% से ज़्यादा नहीं, give me 25%. RV still said, okay, take 25%. 5% more does not make me rich or poor, just close that. Now RP said, we cannot pay you. I can only pay you maximum 50,000. And I know the RP, I have spoken to RV personally many times. So I asked RV, the registered valuer. He said, this do not even cover my GST, which I paid on the invoices I raised. So the invoice which I raised on you, at least pay the GST amount. This 50,000 is just like OPE for whatever travel that don't even cover. So he said, because I have only budget of 50,000, we will only give 50,000. So he gone to NCLT and saying that my fees is not paid. You need to consider. NCLT dismissed the application saying that when the company is already shut down, in terms of CRP proceeding has been shut down, we cannot put a case on anybody. So it becomes a functions officio. So this application cannot be even entertained. So after losing NCLT, he went to NCLAT. NCLAT again added, it's like jalebi namak chhedam. Again, NCLAT rejected saying, but we have already paid you 50,000 rupees. So that means why are you coming back to us now? So he did not even like that, which again, NCLAT was not right in saying that certain amount has already been paid. So certain does not mean whatever has been agreed, you need to have paid me there. Then he went to Supreme Court, and the issue was, so we all understand as a professional, we all understand there are two kind of questions: questions of law and questions of fact. Question of fact generally does not go to Supreme Court. The fact will remain a fact. Question of fact generally get addressed till High Court. The question of law goes to Supreme Court, where there was no law. Then the regulator need to take a call who should do what. Because if the law would be already speaking clear, it will not go to upper stage. Where the law is not speaking, there's a question of law, then we go to the Supreme Court. So the question of law was, when CRP has been set aside by adjudicating authorities, then who should determine the fees of valuers under the IBC framework? There has to be some body, there has to be someone to take a call. NCLT view was, RV should go for grievance addressal against IP. So they said, so NCLT said, you make a complaint against IP that IP has not paid me. So RV said, why should I make complaints against IP? I am coming to you, give me my money, get me money, because there is no provision. And after making a complaint, who will pay? IP will not pay from his pocket. IP says, I am working on a limited capacity only for IP case. Then NCLT, Supreme Court rejected the NCLAT judgment also. And NCLAT remitted the proceeding back to NCLT and say, you need to determine the claim of RV for whatever professional charges which have been appointed by RP on started of initiation of CRP. And then appellant was justified in conducting that there has to be a forum which will decide the determination of claim on present case. So unlike IP, unlike value, there could be a forensic expert, there could be a transition advisory, there could be even IP fees also, which would not have been decided. Then this judgment becomes a landmark judgment, how to recover your money. That was the classic case. And now RV can approach NCLT to set its claim in determining. And then he got the fees. And Ayushri, can you make an assumption? Earlier, the RP was asking him to make 25% haircut.
Yeah.
After this judgment, how much haircut he would have given in getting his fees? Any thoughts?
Maybe 30 or 35%.
Not a single penny. He said, now why should I give a haircut when I already won from Supreme Court? He said, I've gone to this extent. He said, I was willing. That's why he says penny wise and pound foolish. He said, I was willing to give 25% haircut, voluntary on my own. But now, since you have not delayed, did that, and now when I went to Supreme Court, he said, not a single haircut I gave. Whatever invoice was agreed, fully was paid along with interest and whatever they do. So that's the way this judgment has become a landmark for all professionals, saying that. Now I'll take, since in the interest of time, I'll take 2-3 judgments, which is helpful for chartered accountants also, and of course valuers also. Since a lot of CAs also do valuations for FEMA cases and other cases where it might help them. So this is one of the classic case of Cinestan Entertainment Private Limited, and it became a landmark judgment because of the two key angel investors were there. So these are high-profile investors. One late Sri Rakesh Jhunjhunwala, C. Rakesh Jhunjhunwala ji late. He passed away last year. So he was one of the investors in that. And another investor was Mr. Radhakishan Damani, which is owner of DMart. And again, one of the highly talked about angel investors in India. So they both invested in a company which was formed in 2013. And the company formed in 13 was the objective of entertainment business. And as we all know now, because of technology, they all are coming on OTT platform. So this company came in that we will make a content in OTT platform like this. So they wanted to raise money. They did a valuation, allotted shares, and based on the valuation report submitted for allotting shares at a high premium, they questioned on tax department. They almost 90 crore rupees they put a tax on the put an income on the company because they say you have raised a premium which is not tenable. Now their answer was, their rejection was, assessee has not done anything to achieve the projections made. So if I would have made a projection of, let's say I will earn 10 crore next year, third year 20 crore, 40 crore later on, they say we could not see any work done by you to achieve such projections. Second, they say you received money. So what did the company did? Company received money from issue of shares and invested in a subsidiary company, associate companies at 0% debenture. So he says it looks illogical to us as a tax regulators. A company is issuing shares, getting money, and simultaneously I'm investing in an associate company with a 0% debenture. He said, had you would have put 9%, 6%, 7%, so at least some income would have been coming to the company. Then how you would be giving money back to the shareholder? That was their concern. So they say that we think the valuation which is done is not right. Assessee did not give scientific base for projections, and we agree for projections, you need to have a story. You cannot just give a scientific base all the time, but there has to be some substance. Then they say company incurred 71 crore rupees loss by selling unsecured convertible debentures and many others. So you are raising capital on premium and booking losses. So that means somewhere you are not paying taxes. That was their intention. So it was rejected, and the commissioner did in a favor of department. So commissioner addition made a taxes. Later on, it went to ITAT. ITAT rejected the order of commissioner and put in favor of company. Then the revenue department went into High Court, saying that ITAT has erred in deleting the additions. They have not considered the sound and reasoning detailed analysis of assessing officer, and that should have been considered. Whatever projections have been made are paper plans and no relation with the reality. So department would not like to lose at such case, because they say if we lose this case, then everyone will take this case in their favor and department will not be able to make additions. So they tried to do their best to tooth and nail to win this case. And then ITT made a certain sensible judgment in this. And ITT said, it is always the prerogative of the assessee to decide how much capital should be raised for business, either for long-term or short-term funding. Department cannot act, and this is a very key judgment which favors the assessee. The risk factor is taken alone by a businessman, and that's why higher the risk, higher the return. The income tax department cannot guide a businessman in the manner risk has to be taken. They say you are not running the business, you are a regulator. You do not step into the shoes of a businessman. Whether if I am buying a painting worth 1 lakh, you may say this painting is abstract. It is just like somebody put a brush in the hands of kid and he do some painting. You say it is of no value. But if I see a value in that, you cannot question the buyer, the businessman. that how to take the risk. You are an armchair consultant or a regulator. So like as a CA, if I tell someone, a client, why are you buying printer or why you're buying a Mercedes, you can even go in a nano, because nano also drives to a location A to B and Mercedes will give A to B. I cannot qualify that, oh, the client has bought a Mercedes from a shareholder's money. It is a businessman call. And so that way they say you cannot question him. Entrepreneur is taking a business risk based on certain projections. So I remember when I was in PwC Mumbai, I had a discussion with the client, and the client says, I'm taking a loan to buy a Mercedes. And my first question was, why are you taking a loan to buy a Mercedes when you have a loan issue? Don't tell that. Who said is taking it is required? He says, you don't understand in our business, and that he was into a jewelry business. In our business, if we don't pump and show, then we don't get value. People should feel from our presence that we are a millionaire guy. They say, if I go into a nano, or with due regards to anybody who is having nano, it's not to demean nano, but just giving an example. He says, if I go in a certain vehicle which does not sound as a prestigious vehicle in terms of buyers, I cannot demand premium. To show that we are good and successful, we need to pump and show. So that was a prerogative. So if an entrepreneur makes a certain assumption, certain judgment, department cannot question it. And then they said that whenever a DCF is made by an expert. So when an expert, and luckily the department considered chartered accountant is a valid expert, they say when a prescribed expert is doing a valuation and he would be trying based on his assumptions, you just cannot say this is not right. And the reason the government said, the investors, the reason why department, ITAT and High Court was very favorable in SSEs. And they say the investors, which we call Radhakishan Damani and Lee Rakesh Jhunjhunwala, they say they are not doing charity. They are the investors who will not just put money for any charity. They will put money to make money out of it. So if they have taken investment in this business, they would have taken a call that in future entertainment industry will go on OTT platforms. They might make a huge fortune. It may happen, they may fail also. The judgment may go wrong, the company may go bust, but that does not mean they are doing any charity. So it seems genuine. And whenever you are giving, so that's what they say. The most important judgment here, which we all should take care, which will help us. He said, the court said, see who subscribed for the share. If a sister company is subscribing at a high premium, we can assume that this might be a fake transaction. It can be a routing of money. But when the shares are subscribed by outsiders, who are the top investors of the country, if they can see a potential in that company, then valuation should be accepted. A assessing officer and CIT cannot question their wisdom. Those who are top investors of the company and they're willing to put their money. So whose skin is in the game? If I am putting my money, at least I know more than you. If you are a consultant and say, do not put money in this, but I'm putting my money, so I'm taking more risk. And especially when I am one of the top seasoned investors of India, and now nobody can question the credentials of late Shri Rakesh Jhunjhunwala or Radhakishan Damani. They are the proven experts in this field. If they are finding some potential in that, you cannot question their wisdom. Later on, the company may go bust, that is fine, but initially you cannot say. So then the court said, and then there's a very good judgment the High Court said, Income Tax Department cannot sit in the armchair of the businessman to decide what is profitable and how the business should be carried. Commercial expediency has to be seen from the viewpoint of businessmen and not from the lens of the regulator. DCF methodology by respondent is a well recognized and well accepted and based on projections. Hence, these projections cannot be compared with the actuals. And that's why the High Court said, valuation is not an exact science. Therefore, do not look into arithmetic precision. Formula will always give you a number which you put in. So do not question on formula. The question should be on the process. If the third party is coming with this number, that means somebody is finding a value in this company. Then you can always justify on the valuation. And since they have said it has not been subscribed by sister concerns, by outsiders, somewhere it has to be a potential. So appellant cannot question their wisdom. So I'm sure, so this is like which department said, the High Court said a very right tone that how a business should be run should not be taught by a tax professional. Department cannot teach a businessman how to run a business. If he's hiding a law, hiding, saving it, evading a tax, then you have a right to come and say this practice is wrong. But how I do a business, you cannot question. So give an example of Mercedes. Let's say if I am buying a Mercedes in the name of company, charging high depreciation, this is a proper tax planning which I am doing. You cannot question why you bought in the name of company. Company will not drive a car. You should have bought in your personal name. That's my tax planning. Similarly, if you recall, few weeks back, one GST department gave a notice to a assessee saying that you bought an iPhone in the company and claimed GST on that. Considering your business volume, this is not a good investment. So I am rejecting. You don't need a house. Their observation was you don't need a high-end phone for doing the business. So I'm rejecting the input credit on that. So a department cannot take these kind of stands. Whether I should buy Oppo or I should buy iPhone, it's my call. And I understand where department is coming from, because the department will be saying that iPhone ki GST mein hum Oppo kharid sakte the aap. So why you have not taken a lower phone? So that's a department's call. So this is one of the classic judgments happened. In case if you have any questions coming in, then I can take before we go for last case.
No questions yet, sir. We can carry on.
One important thing which need to be taken care of, if the documentation is there with you, then whatever valuation you do, nobody can touch you. But if your documentation is not there, and our ICA valuation standards time and again speaks again only, first maintain whatever record you have. So whenever somebody questions, a peer reviewer or a regulator asks you, if you have the sufficient document, your report can easily pass through the test of whatever regulator is doing. But if you don't have them, it looks that you have accepted the numbers of the client and have not applied your professional diligence. Last case of the day for which is Cadbury. So we all like end mein kuch meetha ho jaye. So let's have something specific with Cadbury. This is a classic case where how a minority was extorting the majority. So normally majority threats the minority. This was the other case round where a minority holding less than 3% shares, a group, is causing ruckus to the majority people. Now, we all know that Cadbury was a company which was listed earlier. It was from foreign group. Cadbury is not India, it's a foreign company. So they were listed earlier, but then they realized no point in getting listed because we are a foreign group. We are not here. We don't need to raise money in India. So they delisted. And when you delist, you need to have a lot of buybacks. You need to go for buybacks and all. So they did a buyback. And now there was only very few shares left with public, which they wanted to buy from public. Now to give a buyback and give a acquisition of minority shares under Section 236 of Companies Act, we need to get a valuation done from an expert. And the valuation is done by expert. And our 2CA stalwart professionals have done the valuations of this company. And I give them very high regards to these professionals. So they did a valuation of this. And then minorities objected this valuation. And whatever best you do in a valuation, minorities are always having one clear vision, they follow one simple anthem. And their anthem is, Ye dil mange more. Whatever valuation you give to them, they say, I'm not happy with this valuation, I want more. You come back to 1 week later with a new valuation, they will say, no, this is okay, but I still wanted a more. So that was a problem of minority. Here, the value start from 500 rupees up to 1030. Then the valuation 2.4 was to be taken by. So the company made an offer saying that, look, our last valuation was 1030. Let us give you 1340 based on two values which we appointed in Mumbai. Minority went to High Court saying that we are totally grossly undervalued. We are being suppressed as a minority. We want more. If you see 1000 and 1340, it makes a reasonable 30% offer, which is reasonably good. The shareholder was very smart. Shareholder said, we compared our shares with Bonvita. and Nestle, because Nestle was a similar company. Nestle's value is much higher, so we don't deserve this number. We deserve equal to Nestle. So the court appointed a third valuer. A third valuer gave a company value 1743. So one of the big four firms was appointed and they gave a value 1743. Because if I know that 1300 पे भी problem करेंगे तो थोड़ा ज़्यादा ही दूंगा, because I know the background. So I will say थोड़ा ज़्यादा दे दो, at least चुप रहेंगे shareholder. And he said, I am taking the multiples of Nestle, GSK and Britannia. And that's a problem of giving more information to public. So minorities took this and say, then they challenge on these numbers. So this, and the valuer said, I am not giving a premium to you. I am valuing the company as a whole and then giving you 2% whatever shares. Multiples I am taking based on these companies. I have considered tax in my workings. Nestle and Britannia both were in Uttarakhand at that time tax benefit zone. So they were not paying taxes. So their projections will be different than my projections. Cadbury was paying taxes. So I need to consider that fact. They say, so now see the smartness of minority. Minority shareholders got another valuer. They say, according to our valuer, valuation is 2,500. Now, this is the way you challenge. If you got a report of 1,700, you say, देखो हमारा value is 2,500 कर रहा है, जबकि हमारे value के पास तो information भी नहीं थी company की. Based on our internal resources, we find out the information and we got 2,500. Now we expect the value to do the DCF because the previous valuer has used only market multiples. He has not used DCF. Though this 2,500 was not supported by any data, they just said based on Nestle, whatever Nestle was getting, because Nestle did a transaction similar and they give 2,552 for their minority. They say what Nestle को मिला वही हमें मिलना चाहिए, which is the like a normal kid demands. They say because two are competitors, so we should at least get this much. Court said that this approach is untenable. You just cannot say that other company has got this number, I should also got this number. If DCF has not been taken for any reason, that does not mean valuation is wrong. But then the court said to the valuer कि भाई चलो खत्म करना है, you also do a DCF. And valuer being a direction of court, we cannot say to the court. So he said, okay, sir, whatever you say, we will do it. As a valuer is like जो तुमको पसंद वो बात करेंगे, दिन को दिन रात को रात. Because if I am a valuer, a regulator say ये भी करो तो ये भी करेंगे. Though nobody can dictate a valuer what approach he should follow. It is the valuer's judgment. So if valuer think DCF is not good at that time, market multiples is better. So he has used on that. But now if the minority make an issue that based on DCF, I would get higher value, he would be under pressure. So he said, no, let me also do that. So he did that. And now he said, I will give you 2014. Now you can see from 1030, we went to 1340. From 1340, we went to 1743. Now putting DCF, we got to 2014. Do you think the minority would be happy here? अगर this is the way of completing your demands, तो उसको लगता है अच्छा 2000 पहले मांगा था तो ज्यादा मिला, अब और मांगते हैं तो उससे ज्यादा मिल जाए. Then they again went back to NCLT. They again challenged that. They again challenged to the High Court saying that, sir, this report is also not right. Minority challenge. Now here the High Court said, इतने पैसे में इतना ही मिलेगा. The High Court said, enough of your nonsense. We have been listening you from so long. We are agreeing with the third values report. Either you take it or leave it. Because there has to be end to something. As again said, nothing is perfect. So it may happen, your value might be, let's say 2,200, let's say. But every time you keep opening up, it's a Pandora box. It's like an onion peel. The more you take out, something more will come out. They say whatever the assumptions values have taken, if we are okay with that assumptions, then number is secondary. See, the valuation process is a subjective process and a qualitative process. So if Excel part is secondary, the way the quality factors have been taken care of, if that has been no objections, then we'll not put it. And then the court said, give a final judgment. In order to decline sanction, it must show, if you say that valuation is unreasonable and cannot be accepted face of it, then only we'll reject. Just because you say there might be other methods of valuation, that does not mean whatever the one has done is incorrect. Court will never substitute its own opinion. And the court made a very good judgment. They say we are not a carping critic. We are not a hair-splitting expert. We are not a meticulous accountant or a fastidious counsel. the effort is not to emphasize the loopholes, technical mistakes, and accounting errors. They say we are not a critic, like we'll question on everything. There are like critics, you do everything and they will question. Like you might have seen a very good, sometimes you would have experienced with clients, you do everything for them, they will still come out something. You're not done this, you give on time, they will say, jaldi ko jama, tax late ho gaya, late ko jama kara diya, jaldi jama kara diya, interest loss kara diya, jaldi ko jama kara diya. So you'll find all kinds of certain critics like that. So then we cannot enter into the venture of whether the approach is right or wrong until it's fundamental wrong. So the court said, you cannot just go on in this valuation. Minority, we understand, should not be tortured. But this is not a case, it is a reverse case happening where minority is threatening the value majority every time. And that's what they say, we are not we cannot venture into the extrapolation of other companies. And it is not our expertise, and it's not a statutory obligation of companies to get the best. That's why they stopped it here. And just a fundamental guidance for all professional valuers. Whenever you are doing valuation of minority shares, you need to be very careful and take it as a process that what if my report gets challenged? How can you justify your assumptions? If you work on this thought process, that whenever I'm doing a valuation of minority and my report get questioned, you will always do a right job. That does not mean that you should stop taking assignment of minority thinking that my report will get questioned. We are here to take risk, and risk should be calculated risk. I just cannot avoid any assignment saying what if it goes to the court of law. You never know, even a normal case may go to the court of law. Recently, and I'm sure many of you are aware, recently IBC has taken many actions against registered valuers in IBC cases. So any case can go to any court if somebody complains. Having said that, if you take care of your documentation well, nothing can bother you. So that is most important. With this, I think we should end now here. We can take any specific questions, or anyone has any. Normally in case law, you don't have a question because it is a judgment already done. So your views and my views will not make a difference. But still, any query or anyone has any specific case issue, then we can take it up.
Yeah, so it is, one of the reasons that judgment is already done, but I must say everything was very much clear. I really enjoyed the webinar, and definitely I am taking a lot from this. Just like I told you, it is for the first time I have enjoyed the valuation cases so much, and same I believe from the participant side as well. So we really don't have any of the questions till now, but still, if anyone has any doubt or anything, we have 2-3 minutes. You could just write that in the Q&A box. Questions are welcomed.
And I must appreciate and compliment the way you have done the moderation. Normally, I take many sessions, and most of the time I saw moderator always logs off their video and go off. But kudos to you have kept full time, because otherwise, it looks like I'm talking to the nameplates.
Yeah.
I cannot see. I only see the nameplates on the tag, but it's good.
No, thank you so much, sir. Because I understand this. Making a webinar successful is much more difficult than a seminar. At least in seminar, speakers have the faces in front of him or her, so they get a chance to understand whether they are interested, they're listening or not. But being in a webinar, it takes so much effort for the speaker as well. Like you have no clue who is listening, how they are reacting, and still you managed it very well. And so I believe we are done. We have not yet got any of the questions. Thank you so much, sir. So finally, officially, I'm closing our webinar organized by Valuation Standards Board of ICAI under the chairmanship of CA Hansraj, sir, vice chairmanship of CA Preeti ma'am, and with a brilliant speaker, CA Sumit sir. So thank you so much for the participant being patient, and I hope you are taking a lot for this Sunday. Meet you in the next webinar. Thank you so much. Good day. Bye-bye.
Thank you all. Have a good day. Thank you, board.
Yes, sir. You too, sir. Thank you.